Have the related case of People versus Kenya Ali Hyatt. There'll be 15-minute arguments in this case. Do I understand, counsel, the time will again be shared in this case?
That is correct, Your Honor. I'm going to be giving 5 minutes of my time to Mr. Prosecution.
Okay, please proceed. Thank you.
Thank you. Good morning, Your Honors. May it please the Court. My name is Joseph Salka, Assistant Prosecutor with the Genesee County Prosecutor's Office. I understand I manage my own time. I'm going to respectfully request 2 minutes of my time for rebuttal, and along with Mr. Prosecution, he has already given 5 minutes of my time. And I do waive the question-free time period. Your Honors, the Court of Appeals' heightened standard of review must be reversed, and the defendant's sentence of life without parole must be reinstated because Miller v. Alabama did not alter the appellate standard of review for sentences, and the Court of Appeals misapplied Miller v. Alabama. In this case, it was the trial judge's decision based on the factors, on the facts of the offense and the offender, and after careful consideration of those facts, to impose life without parole. The Court of Appeals correctly applied the common threefold standard of review on appeal, but it then took the standard that Miller told sentencers to apply and transformed it into a standard that appellate courts must apply. And it amounts to an improper de novo standard of review because it allows the appellate court now to reconsider all of the same facts, all the same factors already in the record, and then make its own determination as to whether or not these facts and factors represent a reflection of irreparable corruption or transient immaturity for the juvenile defendant, and therefore do not afford proper deference to the sentencing court. Sentencing principles have always, not always, but in the modern era, been part of the idea that the sentencer, the trial court, is in the best position to impose the most reasonable and proportionate sentence due to its unique situation, as stated in Gall v. United States most recently, with respect to the federal guidelines. The court even said the uniqueness of the individual case does not change the deferential abuse of discretion standard of review that applies to all sentencing decisions. When we look to what Miller said, it is highly important that Miller focused on the sentencer. Nowhere in Miller v. Alabama or in Montgomery v. Louisiana did the Supreme Court talk to appellate courts. All of the factors that a trial judge in Michigan should be considering are appropriately left to the trial judge to consider. And when on appeal, an appellate court should be asking, reviewing a sentence for life without parole, or perhaps even a term of years after a Miller hearing, whether the trial court's employed procedure and its rationale for the sentence imposed is reasonable and proportionate under Miller v. Alabama. I agree with my colleagues who were just speaking and with some of the questions by the justices about what does irreparable corruption and transient immaturity mean. Chief Justice Markman, asked about the California case where we cited in our brief about an encapsulation, and that is exactly what we believe Miller v. Alabama was talking about when it did not impose formal fact-finding requirements. I am not going to stand before this court and say a person can be deemed irreparably corrupt, as Justice Viviano's questioned. That's a future prediction because no one can know in the future for sure what could happen, which is why the dissent respectfully criticized the majority's characterization when it said we think sentences of life without parole should be rare or uncommon, but an ultimate determination as to whether or not a defendant, a juvenile murderer convicted in Michigan under our statute deserves life without parole, after considering all of the factors, the court is not asking, yes, I find this as transient immaturity, or no, I find this as irreparable corruption. It is a totality of the circumstances analysis that Chief Justice Markman stated. The trial court is to consider everything. There is no weighing analysis. There is no balancing analysis with respect to two different principles. It is a total encapsulation when the sentence is imposed. And a trial court judge need not say, I believe this is irreparable corruption, therefore you are sentenced to life without parole. It is what we already apply in Milborn, what this court just reasserted.
Well, so maybe on your view, the trial court doesn't have to say those words. I believe the defendant is irreparably corrupt. But if the judge doesn't say, the judge could instead say, I believe that the sentence of life without parole is proportionate. And maybe that would do, but on appellate review, the question's going to be the same, right? I mean, I suppose it doesn't matter whether the judge says some magic word.
Well, respectfully, the court
draws the same conclusion using some different words, right?
Well, on appellate review, we are not asking whether or not the sentence is, whether or not a juvenile who is sentenced to life without parole or transient maturity, that's the sentence that is the correct sentence. The question on appeal is whether or not the trial court followed the appropriate process and gave a reason and valid reasons for imposing the sentence which was chosen. And I have to say that the sentence that's imposed is really a function of the reasons in and of themselves. A reasonable sentence can't be determined reasonable unless reasons are given. So what the court will be looking at on appeal is to say the trial judge, under our statute, is required to follow a certain process. First, did that trial judge follow this process? Were the parties in compliance with the process? Then the appellate court will be looking to the record to see what the sentence was, but then will determine from the sentence what were the reasons the trial judge used to support its basis for imposing the sentence. I don't think this court can ask anything more than a reasonable sentence. Perfect sentences don't necessarily exist outside of mandatory sentences. So the issue is not whether or not a sentence is perfect. It is reasonable and proportionate. And as this court stated in Steenhouse and Mercer recently, nothing about the Sixth Amendment required us to jettison our sentencing principles on standards of review for sentences. I see nothing in Miller or Montgomery versus Alabama that requires our courts to jettison the sentencing principles that we have applied now for decades, the common threefold standard of review. The trial judges sit in the best position to see the facts, see the offender, understand and judge the credibility, particularly in this case where the defendant gave multiple conflicting statements about his memory about what occurred, what didn't occur. And the judge, the trial judge, not the appellate judges, are in the best position to determine what weight to give and how that influences the ultimate decision as to whether or not this can factor into a reflection of transient immaturity or a reflection of irreparable corruption. This
Counsel,
isn't.
When a defendant is challenged, a defendant who's sentenced to life without the possibility of parole is on appeal challenging that sentence as a violation of Miller, right? And that's effective. That's a constitutional challenge, isn't it?
Yes, I would agree.
We review most constitutional challenges de novo. Is that right?
Well, there's a difference. If the defendant is challenging the sentence of life without parole as unconstitutional in the sense of the Eighth Amendment, that's an Eighth Amendment determination. But if the defendant is challenging the sentence as not proportional under the Constitution, that, while it might implicate the Eighth Amendment, as Milborn does, the question is not a de novo standard of review. It is the common threefold standard of review to determine the discretionary aspect that the trial judge engaged in to impose that sentence, not whether or not the sentence is permitted under the statute.
So your view is, as long as the defendant says, I'm challenging this as a violation of the Eighth Amendment per Miller, the defendant should have de novo review?
No.
Oh, I thought that's what you just said.
I'm sorry. If that was, no, I don't mean to say that at all. If they're challenging it, and I guess the best way to say this is, if the challenge is, as defendant raised in an application, we can't have life without parole at all. That's a mandatory, that is a de novo.
What if it's just the defendant just saying, you know, I am challenging my life without parole sentence under Miller because I am not the rare, irreparably corrupt. Why isn't that a constitutional challenge that should be reviewed de novo? Because
we already know from Miller and from Montgomery, well, for Miller, that the court did not categorically bar life without parole. That is one of the things that's explicitly stated. If life without parole is not categorically barred, it cannot be a de novo review if the sentencing judge followed the process that's required by Miller and our statute, and then exercised its discretion in imposing a life without parole sentence.
So you're saying that the judge's conclusions, as long as the judge follows the procedures, there should be no substantive review? The only review under the Eighth Amendment is procedural review?
No, it's a combination, and I can't give this court a great answer because from my reading of the federal case law, they seem to combine substantive and procedural review. And they try to draw distinctions, but it's not clear to me. But what I'm saying, there is a certain process that must be followed. We can agree on that. That's what the prior case that this court heard is about. It's about a process. Then there becomes the substantive process of reviewing a sentence that's imposed under our statute. Now, the courts on appeal cannot substitute their judgment for the trial judges. Even though they may disagree, it is within the common threefold standard of abuse of discretion that those judges sit in the best position to impose the sentence. Therefore, going back to my original position, the reasonableness of a sentence is in part a function of the reasons that are given. Justice McCormick asked a question about, well, if a trial judge says, I find no mitigating circumstances, I impose life without parole. That's going to be, in my opinion, and what this court, I believe, should hold, a substantive review of the sentence, not necessarily the procedural aspect, but a substantive review. And to answer your question, Justice McCormick, I do have a slight disagreement with Mr. Restuccia, who I usually don't, but I believe our statute creates no presumption, that there is not a presumption in favor of a term of years, and there's not a presumption in favor of life without parole. Because our statute says the courts are required to engage in the analysis of mitigating and aggravating circumstances and then impose the appropriate sentence. There's nowhere does this ever speak of life without parole being a presumed or not presumed sentence. Same with the term of years. With that, I do need to allow Mr. Restuccia to speak at this time. Thank you.
I just have 2 points, and I may it please the Court, Eric Restuccia from the Attorney General's office. One question is what the standard review is on appeal, and the second is what's the standard of decision. Standard review, I think, is the traditional one, Milborn, abuse of discretion. And I think the question about the constitutional standard being de novo, I think Mr. Salka's answer is right, but I want to kind of just elaborate on it. Think about the Miller factors. The statute says consider the Miller factors. And you look through them, and they talk about immaturity, family, home, circumstances of the homicide offense, how he might have been charged and convicted of lesser competencies, the possibility of rehabilitation. So we have all that description, right? Well, that's a very specific to that particular defendant. I mean, you think about the way the constitutional claims are used to review de novo, these facial challenges, global assessments. Can we categorically bar this offense? This is a very traditional review of a sentence, which, think about this. For this case, Judge Fullerton had a 9-day jury trial, took I think a day and a half of testimony with respect to the sentencing, and then we have the Court of Appeals sitting, for a half hour. The Gall case from the United States Supreme Court explains why we have this abuse of discretion standard. The sentencing judge has access to and greater familiarity with the individual case. The sentencing judge is in a much better position than an appellate court. So the abuse of discretion standard, we talk about the range of principled outcomes. It doesn't mean there's no review, but we think, well, here's the offense. Does that really make sense? We look at what the court said. We then have a review, but it's not a second guessing. It's not a de novo. This is the sentencing judge's decision. But then we look at the standard of decision. We know it has to be, we know from the United States Supreme Court, we've heard this description rare. Montgomery uses that phrase several times. It doesn't create a presumption. And the reason we know that is it's a demanding standard. But that's kind of like, I think the analogy, the best example would be if I have a teacher who's a very hard grader. He says, I'm tough, but there's no curve. And if I look at my students, let's say I have brainiacs. Well, everyone's going to get an A. In the state's view, when we look at the people against whom we've gone, these 250 offenders, I know there's been some talk about rarity. Well, ultimately, rarity doesn't talk about it doesn't talk about an individual, it talks about the aggregate. So ultimately, it's not a standard, really. You can't look at an individual and say, is that person rare? You can only do that ultimately, the ultimate value is not rarity, it is reparable corruption. But in the state's view, and even looking at these people in aggregate, these are like the brainiacs. Because you think about since 1961, the oldest offenders committed this crime in May of 1961. We're talking about, I put in my brief, 4,500 juvenile homicides, something like that. But there has been a culling. Berrien County has, since 1981, 36 of these juvenile murderers. Only 12 of them got life without parole. They have already done this culling. So when we have then this these pending cases of 250 for which the prosecution is seeking life without parole. In our view, these are the brainiacs. These are the people who are the rarest of the rare. They are a special subset of dangerous offenders in view of the state. Of course, these sentences haven't occurred. This is the retroactivity component of this piece. But the point, though, is there is no presumption that these people, when resentencing or given a sentence in the first instance, that life without parole is off the table. In a way, in fact, in the brief, Mr. Saucus said we disagreed. I think the same, frankly. I don't think there is a presumption of life without parole. Really, it's that there is no presumption. The sentencing court's asked to make a decision between, it's a range. There's a statutory range. You make the decision. Here are the two possible sentences. Show us your evaluation, your considerations. Think about the individual factors and make your decision. There is no presumption, and there's no necessary fact, and on appeal we review for abuse of discretion.
My name is Ronald Ambrose. I'm
Why don't we have
appearing
one
on behalf-
person at a time, please?
Ronald Ambrose. I'm appearing on behalf of Kenya Hyatt. I have Jessica Zimberlin that is going to be arguing on this case, so I'm going to just turn it over to her. Thank you.
May it please the Court, Jessica Zimbelman, appearing on behalf of Amicus Curiae, the State Appellate Defender Office. The prosecutor mentioned that we can't ask for more than a reasonable sentence, but we can here, and actually the Supreme Court in Miller and Montgomery demanded that we have constitutional sentences. I waive any free fire zone, and I'm open to the Court's questions at any time. There is, the Court of Appeals was correct to impose a heightened standard of review here, but should have called it for what it was, which is a de novo standard of review, because this involves a constitutional question. Montgomery was clear that Miller created a substantive rule of law that only the very rare offender who was incapable of reform or irreparably corrupt could be sentenced to a life without parole sentence. Therefore, that is a constitutional question. And yes, the traditional threefold standard of review is often cited in a lot of the briefing here, and there is room for a mixed standard, because this ultimately is a mixed question of fact and law. Any factual findings by the fact finder, whether it be a jury or a judge, would be reviewed for clear error. But the constitutional question is reviewed for under de novo review. Just because proportionality is mentioned in Miller and Montgomery and the Court's precedent, that's Eighth Amendment proportionality, which is very different than a Milborn proportionality analysis. In fact, the straight abuse of discretion standard in Michigan sentencing jurisprudence is used in Milborn and, of course, brought back by this Court in Steenhouse. Those are for departures from the guidelines. That is what that proportionality review does. It looks at whether the sentence is proportionate to the offense or the offender. We're talking about something very different here when a juvenile is sentenced to life without parole. This is more comparable, in fact, to this Court's decision in Hardy, where this Court noted when interpreting the sentencing guidelines that facts are reviewed for clear error, and whether those facts can be properly used to score a variable is a question of law that's reviewed de novo. And in fact, this Court noted in Hardy that abuse of discretion used to predominate in our sentencing review, but then the legislature curtailed the discretion of the trial court by enacting the legislative sentencing guidelines.
So, counsel, so I'm just trying to envision, so the way this looks is the factual findings that the trial judge makes that either aggravate or mitigate or both, or, you know, are the Miller factors are reviewed for clear error. You agree with that?
Yes.
And so, but then based on those, the trial court has made some determination that this particular defendant is one of those rare, unique, irreparably corrupt, however we want to think about whatever the category is that puts them into the eligible category for life without possibility of parole. It's that irreparable corruption that gets reviewed de novo by the appellate court?
The rarity.
The rarity.
Because irreparable corruption is a factual finding that you need to before you can impose life without parole, but the rarity is the piece that brings in the de novo review, because that is the question of law. So perhaps
the irreparable corruption, you agree with the attorneys for in the previous case that is a factual finding.
Correct.
It's not a moral determination or a legal determination?
No, it is a factual finding.
Okay. So what exactly is the de novo question that the appellate court is deciding?
The de novo question is whether the facts as found by the jury or the judge in whatever, however Skinner comes out, were those properly applied to the law? And the law is only a rare offender. And that word is key in Montgomery. It was used 6 or 7 times in that opinion, that only the rare offender.
Yeah, but didn't the court there say, we predict that it will only be the rare offender? So for example, in Grutter, Justice O'Connor says, writing for the court, we predict that in 25 years, there will be no more affirmative action. I don't know what year that was, 1990-something. So when we're 26 years from Grutter, no more, I mean, does that mean affirmative action is illegal because they said we predict?
The court
Or
did
is
say
this not like that, or why?
it is not like that because of Montgomery. So the court in Miller said, we predict, we think, yes,
Right.
used all of those words about what they thought might happen. Montgomery changed things. And Montgomery changed things by determining that the substantive holding of Miller was that only a very rare offender was constitutionally permitted to be sentenced to life without
But
parole.
what if I'm the first one? What if my state didn't have a system of punishing juveniles with life without parole, but then the state, as is its prerogative, decides, okay, we've decided we're going to allow that to be a permissible sentence for juveniles. I'm the first person sentenced in my state. How's the judge going to know whether I'm rare or not? I don't know how to do that work.
And that's where I think a presumption would come into play. The court in Montgomery came very close, and I think the court below in Hyatt also recognized this presumption against life without parole. And some of the language the court used below in trying to define this exacting standard was really a presumption. And the Supreme Court in Graham also noted how hard it would be for even a psychologist to predict who was irreparably corrupt. And that language was quoted in Miller and Montgomery as well, and by the court below, and that recognized this presumption. It's comparable to what the United States Supreme Court has done with the Sixth Amendment in Strickland, created a presumption because it's hard to go back in time. It's hard to predict. So the court with the Sixth Amendment did what they are doing right now with the Eighth Amendment, which is recognizing this presumption against life without parole. That would give a good starting point to a trial court judge when trying to determine who is the rare offender. And then whether that presumption was properly applied is another question of law that would be reviewed by appellate courts de novo. And that's why a presumption would be proper. Also, the prosecutor's references to Gall versus United States, again, that's referencing departures from a federal sentencing guideline scheme, which is similar to what this court has done in Milborn, which does recognize that abuse of discretion is the proper standard. But again, here, even when you look at our definition of what an abuse of discretion is, it's a decision falling outside the range of principled outcomes. What we have here is a binary decision. Either the person is irreparably corrupt, the very rare person that's irreparably corrupt, then they can get a life without parole sentence under the Eighth Amendment. If they are not, if it's transient immaturity, there are no options. There is no range. Essentially, what the prosecutor is saying here is that any sentence would always be in the range and that we have to defer to the trial court judge as long as some process was followed. That's not how our sentencing jurisprudence has worked in Michigan, nor should work when you have an Eighth Amendment question presented as we do here. If the court has any further questions, thank you.
Thank you. I think you're out of time, so the case will be submitted. Thank you.